Hey there, today we're going to dive into the 7 essential steps for settling an estate after the loss of a parent or a loved one. We all know that dealing with this process can be overwhelming, especially if it's your first time as an estate executor or administrator. But don't worry, when you have a checklist and a timeline of what to expect, you may find that it's not as complicated as you first thought. My hope is that I give you the tools you need to simplify this process. Hi, I'm Lisa Kwashnick. I'm a realtor here in the Sacramento area and also a certified probate and trust specialist. My husband Jim and I have been helping trustees, executors, and administrators gain valuable insight and understanding so they can fast track their time and get more from their gift of an inherited property. In this video, I'll go over the 7 key steps to settling an estate after the death of a loved one so that you can stay better informed by knowing what lies ahead. With any of these videos, I know sometimes I can talk fast, so feel free to grab a notebook and pause the video to take notes. All right, let's get started. Step 1, get organized. First things first, let's get organized. And there are several mini steps in this first step. This includes keeping track of your expenses and the time you spend on settling the estate because you may be entitled to compensation, so don't skip this step. If there's a will and you don't already have a copy of it, look for the will. You need several certified copies of the death certificate, and this is needed to notify banks, credit card companies, retirement accounts, or investment firms, as well as the Social Security Administration. You'll also need a copy of the death certificate for court records if you're going through probate, and for the title company in order to sell the property or transfer title in the future. Going back to the Social Security Administration, you'll want to inform them right away. Your loved one may have set up automatic deposits into their account, and it's best to stop any future payments to avoid having to return any benefit received for the month of death and any later months. You'll need the decedent's Social Security number as well as their birth certificate, and you can look for a copy of their most recent tax returns and any other important information. If there's an empty or a vacant property involved, secure it by changing the locks. You just don't know who may have a key to the home, so get those locks changed right away. And this reminds me, if the property is vacant, you'll want to contact your insurance agent. A lot of times there may be a clause in the existing homeowner's insurance policy that if a property is vacant more than 30 days or 3 months, some coverage is at risk, like theft or water damage from a pipe burst. So please look into the existing policy. Take a detailed inventory of all of the belongings. Some of my most organized clients simply start in one room before moving on to the next. They take detailed photos and catalog the items on a laptop. You'll also need to open a checking account in the estate's name to handle bills, court costs, and potential repairs on the deceased's home. Keep in mind that you can make a master list of contacts that includes any business associates, colleagues, other beneficiaries, neighbors, friends, relatives, and others that you consider important. Step 2, probate attorney. Consider whether you need a probate attorney. They can be a valuable guide through this process, whether there is a will involved or not. How do you determine if you need a probate attorney? Well, it depends on how title of the property was held, if the property was held in a trust, or if the value of the estate is less than $184,500 in California. If the property was not in a trust and the value of the estate is more than $184,500, it's likely the estate will have to go through the probate process whether or not there was a will. Understanding the legal implications is essential, and your probate attorney can help you navigate this. Step 3, file the will and notify. If there's a will, it must be filed in probate court and beneficiaries need to be notified. You'll also need to notify creditors, banks, the post office, utility companies, and any other businesses the decedent had accounts with. Don't forget to cancel subscriptions and notify agencies offering benefits like pension plans. The last thing you want to deal with is returning payments the estate wasn't entitled to. Step 4, take inventory. Take inventory of all assets and consider appraising high value items to assess potential taxes. You're responsible for managing these assets until they're distributed. Now let's delve deeper into this step. It's not just about making a list, it's about understanding the value of the assets. And this could include real estate, investments, personal property like jewelry, furniture, vehicles, and more. Appraisals can help determine their fair market value, which is crucial for tax purposes. So remember that you'll also need to secure valuable assets and keep them in good condition until they're distributed. Step 5, set up a bank account and handle debts and taxes. After getting your letters of administration from the probate court granting you authority to manage the estate, it's time to set up a bank account. This account will be used to collect money owed to the decedent, such as final wages or insurance benefits, but there's more to it than that. You'll also use this account to pay off any debts, funeral costs, and any other expenses that may arise during the process. Speaking of expenses, you'll need an employee ID number or EIN for the estate. Think of it as a replacement for the decedent's social security number, and it's essential for filing taxes on behalf of the estate. You may need to file several returns, including federal and state level estate taxes, income taxes, and final individual income taxes. Staying on top of these financial aspects is crucial throughout the process. Step 6, distribute assets. Once debts and taxes are settled, and if probate is closed, it's time to distribute assets according to the decedent's wishes. Your probate attorney will be a valuable resource here. So let's dig deeper into this step. Asset distribution requires careful attention to detail. You'll need to ensure that assets are distributed precisely as outlined in the will or trust documents. This can include real estate transfers, transferring ownership of vehicles, and transferring financial accounts to beneficiaries. The goal is to make sure that each beneficiary receives their designated share. Sometimes it's a good idea to withhold some funds in the estate bank account for about 6 months to a year so that there's money available to pay maybe a supplemental tax bill or any final bills. Then those funds can be distributed and the bank account can be closed, which takes us to step 7, close the estate. After completing all the previous steps, you can finally file a petition to formally close the estate in probate court. The timeline for this process can vary, but stay on top of statutory deadlines. Now, how long do you have to settle an estate? Well, it depends on factors such as the location, the complexity of the estate, and the quality of the estate plan. Generally, you have as long as you need, as long as you meet all statutory deadlines. Don't rush this step. It's essential to ensure that everything is in order before closing the estate. And remember, settling an estate isn't just for the wealthy. It can be a complex process for anyone. If you found this information helpful, please like, comment, and subscribe to this channel, and stay tuned for more informative videos. I'm here to help you navigate this journey. Thanks for watching, and I'll see you in the next one.